Florida is now in session. The Honorable Harvey L. Jay, Chief Judge, presiding. All persons having business before this court draw near, give attention, you will be heard. The United States of America, State of Florida, this honorable court. Please be seated.
Good morning and welcome to Daytona, the 5th District Court of Appeal. As our marshal just told you, I'm Harvey Jay. I have the honor and privilege to be Chief Judge of this court and also have the privilege today of being the presiding judge. A couple of quick things for the benefit of the advocates today. If you would be kind enough to make doubly sure any electronic device has been turned off or muted. You don't want to be that person during an OA that has something like that go off for all the reasons you know, so I don't need to elucidate that further. The second thing, and this is perhaps equally important, perhaps more important, we don't grant oral argument in every case, as you know. The three cases are here for a reason, which means we have questions about those cases. So if you would be kind enough to do us the courtesy of listening carefully to the questions we ask and doing your best to answer those questions, that would be appreciated. It has at times been a pattern that we get an attempt by some advocates to run around questions, and I don't want to advise you, that's not my purpose here, but obviously there's a reason we're asking the questions. So it would be, on behalf of this panel, appreciated if you would do your best to answer our questions. Having said all that, we're ready for our first case of the morning. That's case number 253501, Agios Corporation St. Mary Pharmacy versus the Department of Business and Professional Regulation. On behalf of the appellant, good morning.
Good morning. May I proceed?
Well, sir, you'd be kind enough to announce your appearance.
Yes, Edwin Bayo, B-A-Y-O.
And Mr. Bayo, would you like any time for a rebuttal?
I would like to reserve 2 minutes for rebuttal. Hopefully I'll have the 2 minutes at the end of my presentation.
All right, so noted. Please proceed.
Thank you. And my co-counsel, Veronica Bayo Clifford, is joining me at the table, and we represent the appellant, Agios Corporation. This court is reviewing a final order that dismissed our client's unadopted rule challenge petition at the pleading stage. Both parties agree that the standard of review is de novo and that the court is reviewing the dismissal to determine if the allegations in the petition, accepted as true, would establish entitlement to relief as a matter of law. This appeal also presents a very significant legal issue. Can an administrative law judge dismiss an unadopted rule challenge filed under 120.56 because the petitioner also has a pending disciplinary case where unadopted rule challenges may be raised?
I have in front of me, among other things, Mr. Bayo, a final order of dismissal from Judge Kilbride, which was the predecessor dismissal order. Mm-hmm. How is that relevant to what we're evaluating today?
How is that relevant?
Yes.
Well, it's relevant to the extent that the department claims that this appeal is a rehash of that dismissal.
And how is it not?
It is not because that petition was 7 pages long. The petition in front of you is 20 pages long. And the petition in front of you benefited from our discovery in the previous case, where we ascertained, for example, the department's legal theory pursuing this matter.
Did anything about the administrative complaint change from the first petition to the second petition?
Nothing changed between that and this. However,
meaning it's the exact same petition.
It is the underlying administrative complaint is the same. Okay. The underlying administrative complaint is the same.
So, and I don't want to cross-pollinate Mr. Bayo. In the civil world, this first order would be dispositive. And I know we're not in the civil world. I know we're in the administrative world. But if it's the same petition, or excuse me, if it's the same complaint, why is this not dispositive? Why is the Kilbride order not dispositive?
Well, the Kilbride order was dispositive as to that petition that was filed. There is nothing precluding us from filing a subsequent petition, particularly after developing additional evidence through discovery, through the deposition of the executive director, who finally gleaned what their legal theory was.
Was the first final order as to the first petition appealable?
It may have been appealable.
And it was not appealed?
It is not appealed, and there is no administrative res judicata under these facts. Certainly, our department has not pointed out that there is.
This is going to be my next question. Yeah. So why would res judicata not apply? Because
it is a new petition under additional evidence that was developed through discovery. The new petition lays a whole number of additional theories why this was an unadopted rule. Those were not available when we first started this process. For example, we had no idea that the department's assertion of jurisdiction over our client was predicated under a specific statute, 499-0121, paragraph 6. That statute deals with record keeping. That statute states that persons required to maintain records include, number one, those that are required to be permitted as drug manufacturers, drug wholesalers, or repackagers, or number two, persons other than listed in number one that engage in the receipt of prescription drugs. So, the department's theory is that this catch-all provision dealing with persons engaged in the receipt of prescription drugs eliminates specific Chapter 499 exemptions that are applicable to pharmacies. If you look at Chapter 499 and Chapter 465, which regulates pharmacy, you will see that the legislature took pains to make sure that there was no conflict. For example, the definition of manufacturer under 499 specifically excludes pharmacies. The definition of repackager specifically excludes pharmacies. There is a definition of wholesale distribution that specifically exempts pharmacies operating under rules of the Board of Pharmacy that are engaged in the distribution of minimal quantities of prescription drugs. Okay?
But just citing a statute in the context of an individualized case doesn't make it a rule, does it?
It does not, to the extent that those statutes are, as the appellant, as the department provided, if those statutes are the reasonable explanations of what the statute means, then perhaps so. But in this particular case, when you're faced with specific exemptions governing the conduct of pharmacies, specific exemption of Chapter 499, using the term persons under this particular provision to eliminate and subsume every other exemption in Chapter 499.
So it's an agency statement of general applicability. Your argument is it's a general statement, agency statement of general applicability if you disagree with their reading of the statute.
It is a statement of general applicability because my client has the same pharmacy permit like CVS, like Walgreens, like Publix, like hundreds of others.
Hold on.
Yes.
You said that it seemed like you were saying that whenever the statute is clear and sort of there's no dispute, that it would not be an agency statement of general applicability. But it sounds like you very much disagree with the other side's interpretation of the statute, and therefore your argument is that because you disagree with their interpretation of the statute, now it's an agency statement of general applicability. Yes or no, and then explain why. I just need to understand what your argument is.
No.
No, okay. What is your argument?
No. My argument, among other things, We pointed out that there's a specific statute in 499 that mandates the department to adopt rules regarding two specific exemptions at issue here: the exemption for minimal quantities and the exception for facilitating the distribution of prescription drugs by providing solely administrative services. Those two exemptions are in the statute. Another statute requires the agency to promulgate rules, mandates, says they shall promulgate rules regarding the receipt, storage, and distribution under these exemptions. They have not done so. Well, indeed, they've done so, and those rules repeat verbatim what the statute requires. So when a pharmacy is engaged in minimal quantities of prescription drug distribution, or minimal quantities of prescription drugs, the statute on 499 does not require that they follow any particular documentation or anything. Okay? That exemption is self-executing. Also, the exemption for facilitating the distribution of prescription drugs by providing solely administrative services. What does that mean? Does that mean if the pharmacy sends the invoice to the physician's office management company that pays for the bills, is that facilitating the distribution? If the pharmacy delivers to the office of the physician, is that facilitating the distribution by providing administrative services? We are left to guess, because there's been no explanation, there's no elaboration on the statute.
So it's an agency statement of general applicability, is your argument. If this statute doesn't answer every question.
It's even worse, Judge, because the statute specifically required them to adopt rules providing what it is, and they didn't.
Providing for the exceptions.
Explaining what the exceptions are, providing some explanation. What does that mean? They have not done so. So I submit.
So application of the statute at a time when they have not yet adopted rules for an exception. If they try to apply that statute in a way that you say the exception might apply, now that, in your view, that is a general statement, agency statement of general applicability, right? Is that where we're at?
It is the conduct in pursuing the administrative complaint and the theories advanced under the administrative complaint that make it a statement of general applicability.
How does that become, let's say that the agency just is ignoring the legislature and not promulgating rules the legislature told them to promulgate. How do we get to the general statement of general applicability, though, when they are applying a statute to one entity, your client?
They're applying statutes that are meant to govern the conduct of individuals that need to be registered under Chapter 499. They're applying those statutes to licensed pharmacies that are licensed under Chapter 465.
They're applying it to your client.
Well,
hold on. They're applying it to your client, right?
That's correct.
Not to, is there any statement anywhere that they're applying it to all pharmacies that are like your client?
What is to stop them?
No.
Okay.
My question, well, answer it or not. It's up to you.
No.
Is there any statement, agency statement, that they are applying the statute to all pharmacies that are similar to your client? Or are they just trying to, they think it applies to your client? Which one is it?
My client is not unique. My client is operating
I know.
a pharmacy.
I'm asking about their statement. What is their statement? Is it that the statute applies to your client? Or is there a statement out there in our record that it applies to all pharmacies that are similar to your client?
Okay. My client was operating under an exemption that says that they can supply up to 5% of their annual volume as minimal quantities. That statute does not require any paperwork, any record keeping, anything. The DDC went in. They did not even make a calculation whether it was 5% or 0.05%. Nothing. They immediately required all of these documentations that would not be required by a plain reading of the statute, because the statute
And,
no
and
sense to require that.
won't you go into court and say, look, there's no requirement for my client to do these things?
We did
Correct?
that. Well, we did that and we
So
tried that.
isn't,
yes.
isn't there a difference between them saying, hey, one pharmacy is supposed to work, you know, this pharmacy is violating the statute versus every pharmacy under the sun has to comply with this requirement, right? Aren't those two different things?
Not under these facts, Judge, because the conduct that's alleged that my client did, my client acted under two very specific exemptions. My client is no different than all the other community pharmacies out there. So if it's applicable to my client, then it will be applicable
We don't
to
know.
any pharmacy.
We don't know if it's applicable, right? I mean, don't you have to go and argue about that?
Well, I believe that would be a nice question to ask the department. How is that only applicable to Agios and not CVS?
Well,
or
your
Walgreens?
position is it doesn't apply to your client, correct?
My position is that that administrative complaint is a reflection of their statutory interpretation and their authority over licensed community pharmacies that are not otherwise under their authority.
So your position is there's no statement of general applicability actually required. We are to look into the agency's mind and sort of say, well, if they think that the statute applies this way, then they must think it applies to every pharmacy this way. Yes?
No, Judge.
Well, where's the
because-
statement?
Well, for example, they said in their administrative complaint that my client needed a repackager permit. The statute says repackager does not include the pharmacy. Clear as the day is long. Their position that my client, a pharmacy that's otherwise exempt from the definition of repackager, needs a repackager permit.
Right, so why don't you just make that argument in the disciplinary action? Why are you making that argument here, right? That's an argument about your client, not about all pharmacies.
Yes. I'm making the argument to make the point that the statements in that administrative complaint reflected positions that they took that are contrary to specific exemptions in the statute that were taken without engaging in the rulemaking
And are
that
those
was required.
positions actually written anywhere, or is it just the fact that they are attempting to enforce the statute against your client?
The administrative complaint is the statement. The conduct is also the statement. By going after a licensed community pharmacy that is operating under specific exemptions in the statute and doing so without adopting the rules that the legislature require them to adopt, that is as clear example as an unadopted rule as I can think of.
When does this not apply? When can the agency bring a disciplinary action or enforcement action where they're not making a statement of general applicability?
You know, if the agency is going after an entity because they failed to maintain records and they were required by law
But
to
maybe they
maintain those
disagree.
records,
Maybe they don't agree that the record statute applies to them, or they think that the agency is applying it in a way that's incorrect.
No, in the case that I envision, if I'm a drug manufacturer licensed by GDC, if I fail to maintain those records, they can show me chapter and verse where those records are required that I need to maintain. That then does not, that is a
But
fact
that's
specific.
because you agree that the statute, you agree with their interpretation of the statute in that situation, right?
I think that it's not just that I agree, it's that you could not take a contrary position because
So
you're
you're
required
again,
to be-
we've come full circle. Your argument is
Mm-hmm.
if the statute is not indisputably applicable to the situation, then if the agency brings an enforcement action or disciplinary action, that's a statement of general applicability. Yes? Because we've come full circle. That's where we started. You started by saying, well, the statute's not clear. We don't really.
No, I don't believe I said the statute was not clear. I think what's clear is that they take a position that's contrary to their own statutes. They take a position to regulate a pharmacy that's otherwise exempt by law And they will claim that if the statement merely reiterates something that's readily apparent, then it's not a rule.
So, but again, if you then read the statute and say, yeah, man, I can't really make a good argument that this doesn't apply, that is a situation, you agree, that's a situation where they are not there's no statement of general applicability then.
That's correct.
But if you look at the statute and say, no, what are they talking about? I don't agree with that at all. Now it's a statement of general applicability, yes?
It's not just, Judge, that I don't agree with it, it's that I'm able to point out specific exemptions that they're ignoring. And I'm able to point out specific requirements by law that
Not
they were
you
supposed
disagreeing
to.
with their reading of the statute?
This is not a matter of philosophical disagreement, Your Honor, and I respectfully submit that the statute says what the statute says. And these are the kind of questions that should have been developed in a 120.56 rule challenge proceeding. The administrative judge took a pass on that. He ruled on a motion to dismiss. No testimony was taken, no evidence was taken. We believe that the judge gave up on his duty under Article 5, Section 21 of the Florida Constitution to conduct an independent de novo review and not defer to the agency's position. That's what the ALJ did. He simply deferred to the agency's position. And on top of that, he dismissed the petition solely because there was a pending disciplinary proceeding, something that under the amendments to 120.57 is clearly not intended. The legislature made a policy choice that
Mr. You're into your rebuttal time.
I'm on the flow. I'll just. But like I said, the legislature made a policy choice that rule challenges are a separate remedy, and that agencies should not do a policy on a case-by-case basis, especially on a case-by-case basis against small individuals like my client, and not the CVSs and the Walgreens of the world. Thank you.
Thank you. On behalf of the department?
Thank you, Your Honor. Andrew Fear, on behalf of the Department of Business and Professional Regulation. With me is Matthew Mears, my co-counsel. May I begin?
Please proceed.
Thank you. May it please the court, this appeal begins and may end with the threshold requirement imposed by Section 120.564 Florida statutes, as Agios, their petition, was required to identify an agency statement of general applicability that constituted an unadopted rule, and to allege sufficient facts showing why that statement met the statutory definition of a rule. Now, the administrative law judge, in both the first and second case, but we are here for the second, concluded that Agios'
We are here about the second, but why is the first final order not dispositive?
We believe that it is.
Under what theory? Under what theory would it be dispositive?
Administrative finality. We had a final order that resolved that issue. We had the same parties in the proceeding. Material facts were substantially the same, having a 5-page versus 17-page petition.
Same complaint.
Same everything. AC didn't change, and they had a 120.68 final hearing opportunity, and it was identified in the Kilbride order as a final order of dismissal. That was the title. So under 120.68, they should have appealed that order if they were unhappy.
They say, hey, look, we found new stuff, right? I mean,
They
I can certainly imagine a scenario where there's some dispositive fact that comes out after the fact, and then it seems hard at that point, right, to say, well, you can't refile the petition even though you have this very explosive sort of evidence that you didn't have before. And I'm not saying that's what we have here. I'm just saying theoretically, right?
Right. So had there been explosive new evidence, I wouldn't be arguing this. There was no explosive evidence. Instead, there was discovery in the disciplinary case where a statement was made about an interpretation that directly relates to Agios. In fact, in their petition, they state that that interpretation was directly about Agios. There was no statement that this was generally applicable. So I think administrative finality should have resolved this issue. And in fact, in our motion to dismiss, I believe we led with that issue. Now, Judge Cohen, he decided to go the way that Judge Kilbride went, where he said that this was an insufficient pleading. It did not meet the requirements of 120.
Cohen was the ALJ in this case, correct?
Correct.
In this case, yeah. I mean, didn't Cohen address the lack of a statement of general applicability in the order, or am I remembering the other order?
No, he absolutely did. He did it 2 to 3 times in his order. I think in the last sentence of the order, he states, and I thought this was good language, that he could not discern what the statement was. So Agios failed on 2 essential items that are statutorily required under 125.64a. They did not identify a statement of general applicability, and they didn't show general application. There were no facts to support it. Instead, there were inferences. There were legal conclusions. Well, if this applies to my client, this must apply to every client. And that is not what this court has said in Vanjaria, or the first has said in Grabaleaf, where we actually had some type of statement of general applicability. In Vanjaria, we had the Department of Revenue with this tax manual, a 5th DCA case, that explained exactly how tax assessments would actually operate. And it had to be used. It was compulsory. There was no way to get around it, and it affected every taxpayer. It had general applicability. That's a strong fact. That's a statement of general applicability that should be turned into a rule. Likewise, in Grabaleaf, we had this industry bulletin following a decision from the first DCA where the agency said, this is this ruling that has come out, and this is how we're going to interpret it. And that was challenged, and the first DCA said, we're not sure that interpretation is as clean as you'd like on its face. So ultimately, because that had general applicability to all of these taxpayers, that wasn't sufficient. Here, we don't have any of that. So the pleading was deficient under 125.64a, 1a, so there was no reason to proceed, and dismissal was appropriate. There was no statement of general applicability. In addition, we have the administrative finality issue, and under Tipsy-Coachman, all of those issues were preserved, right? The department raised that in its motion to dismiss. Agios responded to those issues, explaining, as we just heard, that we had a 5-page petition to a 17-page petition, and some time passed. And then we brought that up within our answer brief as well. So we believe that under Tipsy, we absolutely notified the court, preserved the issue, and if you choose not to affirm based on the pleading issue, then you can go to Tipsy-Coachman as well. But I don't think you have to touch it. I think the record in front of you and the language of Judge Cohen that he could not discern a statement of general applicability is very telling. He was applying 125.64a and just simply said, you did not meet the pleading requirements. Any further questions from the panel? Those are ultimately the points that I came to make. One is the deficient pleading under 125.64a, and then number 2, about administrative finality, and just this, I think, clearly deficient petition for hearing. Unless there's any questions, though, we ask that you affirm the order.
Thank you.
Thank you, Your Honors.
Mr. Bayo, I think you have 37 seconds.
Thank you, Your Honor. And since I have 37 seconds, I'll simply point out that in Vanjaria, which was cited by my client, by counsel, Vanjaria underscores the issue because Vanjaria had to go to a formal hearing, evidentiary hearing. It was after that process that the decision was made. Here, the administrative judge acted not as a gatekeeper. He just dismissed the petition without conducting any review or anything. And we did provide significant reasons, both legal and factual, in our petition. And we respectfully request that this matter be remanded back to DOA for an unadopted rule challenge hearing. Thank you.
Thank you. All right, we've finished the first case. If the second lawyers would let these lawyers pack up before you come forward.